Louie Johnston Jr., founder of the American Constitution Center.org, PatriotPastors.net, and Layman Lessons Ministries. Louie Johnston Jr. from the War Zone.
Hi, I'm Louie Johnston Jr., Nashville, Tennessee, and I'm the founder of American Constitution Center.org, and we're here to talk about constitutional carry and federalism. Constitutional carry is a term defined in the USA in different ways in each of the 50 United States of America. So why are there differing interpretations of the same simple phrase, "is a pursuit of truth," our citizens must understand? For many, it is the right of a citizen to carry a weapon anywhere, anytime, based on the one-sentence Second Amendment to the United States Constitution that reads, quote, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Now that one sentence is the entire Second Amendment that follows another one sentence in our First Amendment that reads, quote, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably assemble, and to petition the government for a redress of grievances." Our brilliant founding fathers created our republic of sovereign states and our federalism-based United States Constitution as a series of rules for citizens to govern ourselves by incontrovertible, clear, and concise wording. Now, the Federalist, number 10, was written in 1787, that paper written by James Madison. The essay defended the form of Republican government proposed by the Constitution. Critics of the Constitution argued that the proposed federal government was too large and would be unresponsive to the people. In response, Madison explored majority rule versus minority rights in this essay. He countered that it was exactly the great number of factions and diversity that would avoid tyranny. Groups would be forced to negotiate and compromise among themselves, arriving at solutions that would respect the rights of minorities. Further, he argued that the large size of the country would actually make it more difficult for factions to gain control over others. Quote, "The influence of factious leaders may kindle a flame within their particular states, but will be unable to spread a general conflagration through the other states." My favorite portion of the Federalist paper number 10 is this section proven so prophetic throughout our history and especially today. Quote, "As long as the reason of man continues fallible and he is at liberty to exercise it, different opinions will be formed. As long as the connection subsists between the reason he has and his self-love, his opinions and his passions will have a reciprocal influence on each other, and the former will be objects to which the latter will attach themselves. The diversity in the faculties of men from which the rights of property originate is not less an insuperable obstacle to a uniformity of interests. The protection of these faculties is the first object of government. From the protection of different and unequal faculties of acquiring property, the possession of different degrees and kinds of property immediately results, and from the influence of these on the sentiments and views of the respective proprietors, ensues a division of the society into different interests and parties. The latent causes of faction are thus sown in the nature of man, and we see them everywhere brought into different degrees of activity according to the different circumstances of civil society. A zeal for different opinions concerning religion, concerning government, and many other points, as well as speculation as of practice, an attachment to different leaders ambitiously contending for preeminence and power, or to persons of other descriptions whose fortunes have been interesting to the human passions, have, in turn, divided mankind into parties, inflamed them with mutual animosity, and rendered them much more disposed to vex and oppress each other than to cooperate for their common good. End quote. Our Constitution established our governing system of federalism with deliberate intent to divide governing power, not to resolve every issue that would arise, but rather establish the rules by which tension and conflicting rights and issues arising between many citizen factions about the many different sections of the Constitution would be judged by, in order to ensure power to govern was forever in the hands of the citizens through their elected representatives, the citizens supervised by their voting power. Now, what I said just now is critical, because if we do not clearly understand it, we will never understand our own governing system in the United States of America. So let me repeat it. Our Constitution established our governing system of federalism with deliberate intent to divide governing power, not to resolve every issue that would arise, but rather set the rules by which tension and conflicting rights and issues between the many different sections of the Constitution would be judged by, in order to ensure power to govern was forever in the hands of the citizens through their elected representatives, the citizens supervised. Federalism is our system of government where each state is sovereign within its own borders and shares power with a national government. Federalism is why each state has its own constitution and powers such as being able to choose what kind of ballots it uses, even in national elections. So the United States Constitution's set of rules, combined with our 50 sovereign states that have 50 different unique sets of rules, are the true definition of any constitutional issue, including constitutional carry. Now, the state of Tennessee Constitution defines constitutional carry for Tennesseans in Article 1, Section 26, and I quote, that the citizens of this state have a right to keep and to bear arms for their common defense, but the legislature shall have power by law to regulate the wearing of arms with a view to prevent crime. End quote. So the Second Amendment states the right of citizens to keep and bear arms shall not be infringed, which means shall not be violated. But the Tennessee Constitution states the legislature shall have power by law to regulate the wearing of arms with a view to prevent crime. This conflict between the Second Amendment of the United States Constitution and the Tennessee Constitution, Article 1, Section 26, is actually a perfect example of federalism at its finest. I am a lifetime National Rifle Association member and an endowment member of the NRA, as well as a member of the Tennessee Firearms Association for many years. A federal and state association advocating for Second Amendment rights, but whose leadership differ greatly even on the very definition of constitutional carry. Now, this public Facebook exchange I had is a perfect example of countless debates on constitutional carry while campaigning statewide for 18 months, advocating for my friend Bill Lee during his campaign for governor. Mr. C. Richard Archie is, like myself, also an endowment member of the NRA and a leader of the West Tennessee chapter of the Tennessee Firearms Association. Mr. John Harris is a Nashville attorney and founder of the Tennessee Firearms Association. Neither one of these good men understood Bill Lee in his campaign for governor, and I had a deeper but different understanding of constitutional carry, evidenced by this disagreement between themselves. Note, Mr. Archie rightly refers to the Article 1, Section 26 constitutional authority of our state legislature under the 10th Amendment of the United States Constitution to make laws requiring a permit to carry a firearm in public places and ban guns in certain public facilities. But John Harris defines constitutional carry as, quote, letting citizens carry guns openly or concealed without a permit, which it really is better defined in Tennessee as Second Amendment carry, not constitutional carry, because it denies the state constitution, Article 1, Section 26 authority to regulate wearing of arms with a view to prevent crime, which is true constitutional carry as Mr. Archie articulates it. Every state has the right to regulate for public safety and crime prevention. Bill Lee was the only candidate publicly stating he supported and would defend as governor both the Second Amendment and our Tennessee Constitution right of our legislature to make laws regulating gun carry for the safety of the public and calling for the elimination of paying a fee to the state for a carry permit. Bill Lee constantly stated, quote, we should not have to pay a fee for our Second Amendment right, end quote. Bill and I clearly understood true constitutional carry included the right of our state legislature to make reasonable law governing gun carry for the safety of the public, as our legislators determined in their exclusive authority. Where we disagree with the legislature is only in requiring a carry permit fee be paid to the state for our Second Amendment right to keep and bear arms. That's a citizen civil right that should not be taxed. Carry permit fees reminds me of our shameful state segregation laws, when misguided state legislatures passed laws requiring payment of a poll tax to be paid for the right of a citizen to vote in elections, clearly aimed at denying and discouraging poor citizens their civil rights to vote in elections. A carry permit fee is a state tax, denying and discouraging poor citizens their civil right to keep and bear arms legally. What we've discussed thus far has not addressed another vital part of our federalism system's constitution rights: private property rights. Another area where Governor Bill Lee and I advocated is indeed a vital part of the constitutional carry definition, as private property owners have the right to decide who and what is allowed on our private property. Every Tennessean has private property rights protected by the 5th and 14th Amendments to the United States Constitution and the Tennessee Constitution, Article 1, Section 26. Too few citizens understand. Tennessee Constitution, Article 1, Section 21 states, quote, that no man's particular services shall be demanded or property taken or applied to public use without the consent of his representatives or without just compensation being made therefor, end quote. In 2018, the Tennessee Supreme Court ruled that the state constitution, like the United States Constitution, requires the government to compensate private property owners when governmental decisions or restrictions or regulations take or interfere with private property interests. The lawsuit was brought by Mac and Leanne Phillips, who own more than 15 acres near Clarksville and sought permission to have their land subdivided. The Tennessee Supreme Court explained that under the 5th Amendment of the U.S. Constitution, property owners may seek compensation when a government action results in taking of property. Property may be taken, the court explained, by an actual physical occupation or by government regulations or actions that interfere with the property owner's use of the property. This latter type of taking is known in legal terms as regulatory taking. Until 2018, no prior Tennessee court had decided whether the state constitution, like the U.S. Constitution, requires the government to compensate property owners for regulatory taking claims. Previously, Tennessee courts have addressed only physical occupation and nuisance-type takings claims. In its 2018 decision, the court discussed the similarities between Article 1, Section 21 of the Tennessee Constitution and the Fifth Amendment of the United States Constitution. And they held that the state constitution protects the rights of Tennessee property owners to receive compensation for a regulatory taking of property to the same extent as the United States Constitution. The court remanded the claim before it to the trial court to determine whether, on the facts of this case, the Commission's denial of the property owner's request to subdivide their land actually amounted to a regulatory taking of property under the Tennessee Constitution, for which compensation is due. Read the opinion in Mack Phillips versus Montgomery County, authored by Justice Clark. So our federal and state constitutional rights to control our private property are indisputable. How does that factor into the constitutional carry issue? Well, private property owners have the constitutional right to determine who and what is allowed on their property. Private property owners includes property owned by the federal, state, or local governments, such as courtrooms, public office buildings, schools, universities, jails, prisons, hospitals for mental health as well as physical health, all of which our state's police powers, protected by the 10th Amendment, and our state constitution grants our state legislature the authority under Article 1, Section 26 to regulate the wearing of arms with a view to prevent crime. A private property owner in Tennessee has the right to decide who and what comes on their property. And some citizens are adamantly opposed to allowing a person wearing a gun to wear it on their property, even though the Second Amendment says what it says, and the person wearing a gun has a legal carry permit. That property owner's rights are absolutely equal with the right to keep and bear arms. Both are protected under federal and state constitutions. The classic example of federalism. So, how are these differences resolved? Article 3 of the United States Constitution is the supreme authority on constitutional issues in controversy. Section 1 reads, quote, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish." Now, Section 2 reads, quote, "The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States," end quote. All issues in controversy regarding Second Amendment carry versus true constitutional carry is determined by the Supreme Court of the United States. The late, great Justice Antonin Scalia, known as the most conservative Supreme Court justice in modern history, wrote the majority opinion that prevails since 2008 in defining true constitutional carry in the case of District of Columbia versus Heller. So let's review material portions of Justice Scalia's Heller opinion together. Quote, "District of Columbia law bans handgun possession by making it a crime to carry an unregistered firearm and prohibiting the registration of handguns. Provides separately that no person may carry an unlicensed handgun, but authorizes the police chief to issue 1-year licenses and requires residents to keep lawfully owned firearms unloaded and disassembled, bound by a trigger lock or similar device." Respondent Heller a D.C. special policeman, applied to register a handgun he wished to keep at home, but the district refused. He filed this lawsuit seeking, on Second Amendment grounds, to enjoin the city from enforcing the ban on handgun registration, the licensing requirement insofar as it prohibits carrying an unlicensed firearm in the home, and the trigger lock requirement insofar as it prohibits the use of functional firearms in the home. The district court dismissed the suit, but the D.C. Circuit reversed it, holding that the Second Amendment protects an individual's right to possess firearms, and the city's total ban on handguns, as well as its requirement that firearms in the home be kept non-functional, even when necessary for self-defense, violated that right. Quote, point 2, quote, like most rights, the Second Amendment right is not unlimited. It is not a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. For example, concealed weapons prohibitions have been upheld under the amendment or state analogs. The court's opinion should not be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. Miller's holding that the sorts of weapons protected are those, quote, in common use at the time, finds support in the historical tradition of prohibiting the carrying of dangerous and unusual weapons, and that's on pages 54 through 56. Point 3, in Scalia's opinion, he says, the handgun ban and the trigger lock requirement as applied to self-defense violate the Second Amendment. The district's total ban on handgun possession in the home amounts to a prohibition on an entire class of arms that Americans overwhelmingly choose for the lawful purpose of self-defense. Under any standards of scrutiny the court has applied to enumerated constitutional rights, this prohibition, in the place where the importance of the lawful defense of self, family, and property is most acute, would fail constitutional muster. Similarly, the requirement that any lawful firearm in the home be disassembled or bound by a trigger lock makes it impossible for citizens to use arms for the core lawful purpose of self-defense, and is hence unconstitutional. Because Heller conceded at oral argument that the D.C. licensing law is permissible if it is not enforced arbitrarily and capriciously, the court assumes that a license will satisfy his prayer for relief and does not address the licensing requirement. Assuming he is not disqualified from exercising Second Amendment rights, the district must permit Heller to register his handgun and must issue him a license to carry it in the home. And that's end quote, and is found in pages 56 through 64. So in summary, our federalism system of government is brilliantly designed to ensure we the people have superior governing power in these United States of America through our set of rules in our United States Constitution and our state constitutions. In this specific discussion, we discussed the Tennessee state constitution, but in other states, their state constitution applies. We the people vote to elect a president to appoint justices to the United States Supreme Court and inferior federal courts that will judge only by the rules established in our United States Constitution. We the people vote to elect federal representatives from our state that make federal laws we want and change laws we don't want. Or we vote them out and send another person to do our bidding in Washington, D.C. We the people vote to elect our state legislators and to make state laws we want and change laws we don't want. Or we vote them out and send another person to our state legislature to do our bidding in our state capital city. We the people vote to elect our state governor, to appoint judges to our state courts and enforce our laws fairly and equally, or we vote them out and send another person to do our bidding statewide. We the people vote to elect our county and city representatives, to make laws we want and change laws we don't want, or we vote them out and send another person to do our bidding in our county and city. We the people, under our federalism system, hold the highest office in our nation, the office of citizen. I'm Louie Johnston Jr., founder of AmericanConstitutionCenter.org, for God and country.
Louie Johnston Jr. From the War Zone. Louie is the founder of the Layman Lessons Ministries that procures and provides over $8 million annually in donated food and drinks that feed the homeless and needy, all with no paid staff since 2001. Louie has an MBA degree, over 100 television programs broadcast, and authored 62 books as of 2018, in addition to published columns as well as legislation for 28 states. He founded AmericanConstitutionCenter.org, an online public library teaching America's Judeo-Christian heritage. He founded PatriotPastors.net to train Christian pastors and patriots. Louie founded BlueWingUSA.com. Teams of independent experts providing state-of-the-art solutions to media, marketing, and business efficiency needs. Louie Johnston Jr. From the War Zone. LouieJohnston.com.